What are crypto platforms and what makes them similar or different to other exchanges you might know? Look, there's no reason to treat the crypto market differently just because a different technology is used. That would be like saying drivers of electric cars don't need seatbelts because they don't use gas. That would never fly.
Welcome back to Legal Briefs. I kind of really feel bad about that. I mean, I feel like I can help him with his delivery if he wants, you know, kind of open up his body a little. To be fair, I look like Jiminy Cricket. See the resemblance? In any case, there's many things I want to talk about this week, but most of all, in the Ripple versus SEC case, there was one big crazy filing in the case, and that came courtesy of Attorney John Deaton, and you really have to hear about it. Not only was it the best brief so far in the case, but he filed something which was just kind of a middle finger to the SEC, and I quite enjoyed it. Don't mess with Marines. So let's talk about it and what it means to the case. Let's get going. Gary?
We're good to rock and roll.
For some reason, when Chair Gensler tries to be relatable on video, I have the urge to go check on my children. Something subconscious. Okay, let's get into Attorney Deaton's response to the SEC's personal attack against him and the 68-some thousand XRP holders he represents, which we discussed last video. I think one of the reasons I like this response brief so much is that Deaton isn't primarily a securities lawyer. The securities lawyers are always, I think, cognizant that they will likely litigate against the opposing lawyer again and will likely be in front of the same judge again. So I think there is a certain reserve that comes from that. Whereas, how can I say this? Deaton doesn't give a shit. And I think partly because of this, I think the SEC made a mistake in attacking him personally and opened a door for him to say some things and file some things they probably wish they hadn't. So let's take a look at that. And right out of the box, Deaton goes on the offensive. Quote, although the SEC laments amici's presence in this case, the SEC itself is to blame because of its unprecedented allegations. Indeed, the SEC's XRP is a security per se theory, has been at the issue from the very beginning, close quote. Why start with this? Because the SEC's motion was really to prevent Deaton and XRP holders from being involved at all. And so Deaton smartly throws it back on the SEC and says, you are the reason we are here. All you have to do is change your lawsuit and admit that XRP traded today by those other than Ripple is not a security and we are out. And the SEC refuses to do so. It's a perfect and strong opening in my opinion. And why do I say the SEC refuses to do so? Because if it really wanted Deaton and the XRP holders out, all it would have to do is stipulate with them that the lawsuit does not include allegations that XRP is a security in and of itself. They could stipulate to that. But the SEC won't stipulate to that because that is exactly what they are alleging. So instead of admitting they are 1000% attacking XRP holders, look at the word games they played in their last motion that they filed. Looking at footnote 2 of the SEC's motion to get XRP holders out of the case. Quote, movements mischaracterize the SEC's claims as claims against XRP holders in the secondary market. But while SEC Act Section 5 requires Ripple, as the issuer of XRP, to register its offers and sales for the benefit of actual or potential investors, Section 4 could exempt investors in the market from registration. This is so misleading on multiple fronts. First, notice that the SEC says that Section 4 could exempt investors from registration. But why do they say could? Because they know this statement is not true if they get the verdict they want. I know this personally because I have been told by SEC lawyers directly that my clients who owned a digital asset could not trade the digital assets because a court had deemed them securities per se. That was spoken directly to me by the SEC for lawyers, off the record, of course. So no, that is not truthful, and that footnote receives the Legal Briefs liar, liar, pants on fire designation. But going back to Deaton's response motion, let's get to paragraph 5, where Attorney Deaton responds to the SEC's attacks against him, because that's where things get interesting. Now, as you may recall, the SEC went onto Twitter and YouTube and unprofessionally, in my opinion, attacked the attorney personally, hoping that the judge would be so offended by his use of the A word or other things here and there that she would throw him out of the lawsuit altogether. Well, Deaton takes that personal attack and in this brief throws it right back at the SEC and then some. Quote, nothing presented by the SEC warrants a reversal of this court's decision to allow amicus participation. In truth, the SEC's personal attack is a retaliation over my efforts demanding an investigation into the massive conflicts of interest related to the June 14, 2018 Hinman speech declaring Ether a non-security, close quote. Say what? I mean, does Deaton know for 100% fact that that is why the SEC is attacking him? Probably not, but he latches on to the possibility, and from there, look what he files into the court file in the case. Looking at John Deaton's declaration number 4, quote, attached here too as Exhibit B are true and accurate copies of William Hinman's emails indicating Hinman was informed by the SEC's ethics office that he was barred by criminal statute from contacting law firm Simpson Thacher, along with emails establishing that Hinman continued to have contact thereafter, close quote. Yep, that's right. Deaton goes right through the crack in the door and drops that hand grenade right in the courtroom. He files evidence that former director Hinman broke the law as it relates to his speech stating Bitcoin and Ethereum are not securities. And here it is laid out in the documents Deaton files with the court. Looking at Exhibit B to Deaton's motion, this is an email from the SEC ethics attorney to Director Hinman, and it's pretty clear what she is saying. Quote, the analysis is the same for Simpson as it's always been. You have a bar under criminal financial conflict with Simpson because you have an ongoing financial interest in the firm. Meeting with them while having such a conflict is not permitted. As we discussed during your briefing, even calls with them are not permitted. And the reason why it was a crime for him to meet with them was because he still had a financial interest in the firm. Actually, he had a quite large financial interest in the firm to the tune of millions of dollars. So certainly a director at the SEC would have stayed away from violating federal law, right? This is an email from Mr. Bonney with Simpson Thacher to Director Hinman. Quote, great seeing you for lunch. Thanks for making time. How about April 2 for the ad hoc group? Close quote. Uh-oh. But I guess that meeting was prior to Mr. Hinman receiving that warning from the ethics attorney, so he probably just didn't know. I mean, the warning wasn't until January 2018, and that lunch was late 2017. Oh, shoot, wait. This is from August 2018, 7 months after the warning. Email to William Hinman from attorney Bonney. Quote, how's it going? Crazy busy as usual? Want to have lunch again sometime? Close quote. And back at him from Hinman. Quote, sounds good. Do any Tuesday or Thursday or even Friday work? Close quote. And I'll not bore you with anymore with the emails of rich dudes planning to meet for fancy lunches and dinners. I just hope they put as much thought into work as they do the menu at a restaurant. Suffice it to say, there were many more meetings detailed in those emails, which are now part of the court file. And so what, you might say? Well, as it turns out, Simpson Thacher, the law firm, Mr. Hinman was very engaged with around 2018, just so happened to be a member of the Ethereum Enterprise Alliance, the EEA. What is the EEA? Let's ask them. From their website, quote, the EEA is a member-led industry organization whose objective is to drive the use of enterprise Ethereum and mainnet Ethereum blockchain technology as an open standard to empower all enterprises, close quote. Well, that doesn't look good. Mr. Hinman was illegally meeting with Simpson Thacher, which was a member of an Ethereum support group, all around the time he was writing a speech which gave Ethereum a non-security designation. Well, that was probably just a coincidence. After all, the Hinman speech also declared Bitcoin a non-security, and surely Simpson Thacher doesn't have a stake or didn't have a stake in Bitcoin or anything like that. Oh, crap. Look at this tweet from Attorney Deaton. Quote, in 2019, while Hinman was Director of Corporation Finance, Simpson Thacher led the IPO of Canaan, a Chinese company that sells Ethereum and Bitcoin mining hardware, close quote. Well, it looks like Simpson Thacher did stand to benefit from a Bitcoin free pass as well. And just to stay with Deaton's tweet for another second, quote, Hinman was being paid pursuant to his then profit-sharing arrangement while he was working at the SEC. In a financial arrangement like Hinman's, strict criminal conflict laws are in effect. 18 U.S.C. 208 prohibits you from participating personally and substantially on behalf of the federal government in any particular matter in which you have a financial interest, close quote. And there it is. I can't really add to that. That's pretty straightforward. Bill, do you have anything to say?
When we look at Bitcoin or if we look at Ether and the highly decentralized nature of the networks. We don't see a third-party promoter.
You mean you weren't a third-party promoter, Mr. Hinman? See what I did there? In any case, this is now all out there in the public and in the court file. And to bring it back to the Ripple versus SEC case, what difference does it matter? Well, maybe nothing, but I think something. Allow me to explain. Now, not to rag on securities lawyers, but it seems to me that they handle a much smaller caseload and get to jury trials much less often than lawyers such as Deaton and myself, because often there's no issue for a jury. And jury trial lawyers understand one thing. There's really one big battle in a case and a bunch of smaller ones. The big battle is to have the jury find your client the good guy. That's what it's all about. Look at the Johnny Depp trial. Johnny Depp won some small battles, but he also lost some. But he won the big battle, which was that the jury liked him. They thought he was a pretty good dude. At least a better dude than Amber was a nice lady. And once he won that battle, he won the case. And in this case, Hinman has somewhat become the face of the SEC, for better or worse. He gave the speech, he was deposed, he obviously towed the party line during the deposition. He was still at the SEC when the decision was made to bring this lawsuit against Ripple. And now we also know that his speech was considered market guidance by the SEC. So insofar as the judge sees Hinman as the face of the SEC, and now his dirty laundry is fluttering in the wind for all to see, including for the judge to see, yes, I do think that it matters to the case. I don't think the Ripple lawyers will address it because it's not black letter law relevant, but at some point Judge Torres will probably become aware of the facts we went over today and what they mean, and I think it will make a difference even to a judge. Which leads us finally to the judge, and what did she decide in regards to Deaton's motion to file a brief about whether the SEC's expert opinion will be considered by the court, and the SEC's motion to strike Deaton and XRP holders from the lawsuit altogether. The answer is the prototypical lose the battle but win the war. Here's the judicial order, and here's what it says, quote, in that order, which is the court's prior order allowing amicus, the court stated that such assistance will be most beneficial during briefing on dispositive motions. Here the court finds that it would not benefit from Moven's assistance in evaluating the qualifications of the SEC's expert. Movens may file an application to brief their concerns regarding the SEC's expert and other relevant and helpful matters with respect to the parties' contemplated motions for summary judgment, close quote. First and foremost, the judge denies the SEC's motion to remove Deaton and XRP holders from the suit by basically ignoring it. It's like it wasn't even worth her consideration. Second, the judge denies Deaton's motion to intervene at this time in the expert witness issue. That's the battle that was lost. But the judge then all but invites amicus participation in the summary judgment motions due in November, and also suggests that Deaton can chime in on the SEC expert qualifications, or lack thereof, at the same time in November. So yes, I would consider this a complete victory for XRP holders. Congratulations if you are in the lawsuit. See you in November. Thanks for watching. I'm out of time. Have a wonderful week.
There's two ways to do anything, the right way and the wrong way. If you want to be right, do things the right way. Because if you do things the wrong way, that's the foolish way. And only fools do things the foolish way, which is the wrong way, right?